I am the chair of our firm's Health Law Group, and welcome to today's webinar. Today, this is the next in our series of compliance webinars that we offer to friends and clients of the firm. Today, we're going to be talking about the HIPAA security rule and various cybersecurity issues. These are the things we're going to talk about, both the security rule, its enforcement under the rule, the requirements. I'm going to provide some certain resources to help you cover the rule because it's pretty complex and we're certainly not going to be able to get to it in the 45 minutes or an hour that we've got today. I'm also going to touch base briefly on the proposed security rule changes that are currently pending. I'm going to be talking about some of the other laws that are out there affecting cybersecurity, in addition to some of the recent changes to the security rule and otherwise. And finally, end up with a few other cybersecurity resources for you. So last week we talked about, or a couple of weeks ago, we talked about the HIPAA privacy rule and the breach notification rule. Today we're going to be talking about the security rule. I wanted to note that HIPAA is actually the Health Insurance Portability and Accountability Act. It's HIPAA, not HIPPA. The HIPAA rules only apply to certain covered entities, and with respect to the security rule and the breach notification rule, the business associates of those covered entities. Covered entities include healthcare providers, but not all healthcare providers. It's only those healthcare providers who engage in certain electronic standard transactions that are defined in the regulations. So if you are a purely paper practice that's out there, well, then you don't have to worry about HIPAA or the things we're going to be talking about today. But if that's the case, you probably haven't got electronic protected health information anyway, which is what the security rule covers. So make sure that you're aware of that. HIPAA also applies to health insurers, which includes employee group health plans that have 50 or more participants or they're administered by a third party. So most of you who are out there are probably with covered entities or perhaps business associates, but don't forget that HIPAA also applies to your own health plan if you have 50 or more participants or you're administered by a third party. And so your plan is going to have to comply with these rules also. Now, unlike the privacy rule, the security rule does extend directly to business associates. So business associates of covered entities also have to comply with these rules. We'll talk about that a little bit later. Now, I want to talk about why you should care. Unlike the privacy rule, the security rule you need to be concerned about separate apart from the regulatory requirements, because the rule is really here to protect you. What would happen, just think, what would happen if you came in and you logged on tomorrow morning and suddenly you found out that you'd been hit by a ransomware attack? How are you going to be able to function? All of your data now is lost. It's all encrypted. You can't access any of your electronic information. If you're a healthcare provider, how in the world are you going to be able to provide effective patient care when you don't even have any data on those patients, or the data that you may have may be corrupted and you don't know whether it's reliable? How are you going to bill or receive payment for the services that you provide or function without your data, whether it's payroll, doing your accounting functions, paying vendors, or whatever? That's all in addition to what kind of damage that this attack may have on your IT infrastructure, which you've probably spent a lot of money to establish. And then there's also the cost of responding and repairing the problem. Independent of the regulatory concerns, just how are you going to get this thing back up and running? Of course, all of this could result in potential exposure to regulatory fines under lawsuits or bad press. So you need to make sure that you are complying with security rules that are effective, not only for regulatory compliance, but just to protect yourself. As hopefully you all are aware, it is just a staggering increase in cybersecurity threats, particularly towards healthcare entities. Healthcare entities are a prime target for cyber criminals, especially ransomware, because the information you maintain is critical. It can result in literally life and death, and therefore they know that you're probably going to pay them if they hit you with ransomware. Because of that, the number of ransomware attacks, as well as other electronic data breaches for healthcare entities, has just skyrocketed over the past 10 to 20 years. And it's continuing to increase. It is really quite alarming that's out there. The problem with that too is, of course, for all of you who pay the ransom because of on the ransomware attack, because you need to, or is simply cheaper than the other expenses you're going to have, that's funding. That's just funding the bad guys so that they can develop more sophisticated ransomware attacks. So it's kind of this vicious cycle. For those of you who have been hit by a ransomware attack, um, or haven't been hit by a ransomware attack, it's really quite alarming. The bad guys have this down to a science, and they're very professional about it, and they come in there and they run it just like a business. And it is alarming, and you need to make sure that you take these issues seriously. Last year, Ponemon Institute did a study, and they estimated that the average cost for a healthcare breach actually is now up to about $11 million. For a ransomware cost, as of last year, the average cost was $5 million. It seems like it's hard to go on the website anymore unless you get each day. It seems like there's a new news story concerning ransomware attacks. Just yesterday, the OCR published an additional HIPAA settlement because of a phishing scheme. It's just, like I said, it's just pervasive that's out there. And of course, plaintiffs' lawyers have picked up on that. And so you have different law firms around the country who actually go out and target people who have been hit by these ransomware and solicit class actions and bring these class action lawsuits to address that. Now, that's all the practical reasons why you need to comply. If you're not worried about any of that, you still have to be worried about the civil penalties, because as recently updated for 2020, I think it's only through 2024. I don't think we've got the number for 2025 yet, but the penalties under HIPAA for violation of the rules, anywhere from $141 up to $2.1 million, depending upon how badly your conduct was. If you act with willful neglect, it's a mandatory fine of at least $14,000 up to $71,000 per violation, or $2 million per year, $2.1 million per year. If you act with willful neglect and don't correct it within 30 days, it's a mandatory penalty of at least $71,000 up to $2.1 million per type of violation per year. And note that that penalty is mandatory if you act with willful neglect. If you just look at the recent HIPAA resources, they published their settlements, and the vast majority of them over the last year, well, actually over the last 5 years, are dealing with security rule violations. The big ticket items are all security rule violations. This doesn't even include the one that was announced yesterday, where the government settled for $600,000 with a health network that was subject to a phishing attack. If, in addition to all of those penalties that the OCR may enforce, you've got the additional concerns about, because you've got an affirmative obligation to self-report breaches of unsecured protected health information. You've got to report that to affected individuals, which of course it then may turn into, additional problems, because they may decide to try to sue you, or they may pursue, bad PR and other things like that. You've also got to report to HHS if the breach involves more than 500 persons, which commonly does in the case of security rule violations. You've got to report it to local media. In the future, under the HITECH Act, the government, the Congress had said that that affected individuals can recover a portion of the fines or the settlements that come out of these violations. We haven't got the rules on that, but in 2022, HHS issued a notice soliciting input to receive comments on implementing that provision in HITECH Act. So in the future, it's entirely possible that patients or other affected individuals are going to get a percentage of that cut, those penalties that are imposed, which of course is going to increase the chances that they're going to report you to HHS or pursue action against you. Even if you're not worried about the regulators coming against you, if you're an employee, you can get sanctioned for HIPAA violations. If you're an employer, you have an affirmative obligation to sanction your employees. We talked about possible lawsuits. There is no private cause of action under HIPAA, but healthcare plaintiffs' lawyers are out there using HIPAA as basically the standard of care, or to support private cause of action, and therefore HIPAA can become the basis for lawsuits. And finally, state attorney generals can bring their own lawsuit, where they can recover a $25,000 fine per violation plus fees and costs. Now that's important, because when you look at the amount of the penalty for each person whose data is improperly disclosed or affected, then that can be a separate HIPAA violation, which means that the penalties can add up dramatically fast. In addition, to the extent that, Like under the security rule, you were required to put in place certain policies. For each day you didn't have those policies or those safeguards in place, that can also be a separate HIPAA violation. So that's how come you get, 7 figures up to 8, 6 or 7 digit settlements when it comes to security rule cases. All right, that's kind of the background. Let's talk about what the HIPAA security rule is. The HIPAA privacy rule deals with, as its name suggests, privacy of protected health information, but the security rule is both broader and narrower. The privacy rule applies to any kind of protected health information in any form or format. The security rule only applies to electronic protected health information. The privacy rule only applies to covered entities, at least directly. The security rule applies directly to covered entities and their business associates. Whereas the privacy rule is designed to protect the confidentiality or the privacy of protected health information, the security rule is designed to protect not only its privacy, but also its integrity, to make sure that when you go in there and you look at the data, that you know that the data is accurate, that it's not become corrupted. In addition, the security rule is designed to ensure that that data is available if you need it. So if you get hit up with a ransomware attack, either you protected yourself against it or you've got the data backup necessary so that you can go ahead and continue to be operating. So the security rule in some ways is narrower, but in a lot of ways it's actually broader than the privacy rule. What does the security rule require? These are the basic elements of the current security rule. It requires that you conduct a risk analysis. Then you've got to implement appropriate safeguards based on the results of your risk analysis, including certain administrative, technical, or physical safeguards. You've got to execute your business associate agreements with your business associates. You've got to implement and maintain your policies and procedures and document your implementation. And you got to make sure that your workforce complies. Let's talk about each of those. Kind of the bedrock to the security rule is making sure that you conduct an accurate and thorough assessment of the potential risks and vulnerabilities of the confidentiality, integrity, and availability of EPHI. You've got to look at your system, find out where your data is going and the threats that it faces, and put in place, implement security measures sufficient to reduce those risks and vulnerabilities to a reasonable and appropriate level. This is not intended to be a one-time evaluation. The rule states that you have to periodically reevaluate that analysis. The current rule, excuse me, does not include a specific timeline. That is different under the proposed rule. Under the proposed rule, it lists a number of things that you've got to do on at least an annual basis. You've got to, even under the current rule though, you should make sure that it's effective, both from a regulatory and a practical point. That mean that it's an ongoing risk analysis. And as you do so, you need to consider changes that you've made to your health information system, including new equipment, new mobile devices, new personnel, new processes, any of that. The failure to conduct or follow through with the risk analysis, it's one of the citations, one of the factors that the government looks at and cites individuals in the settlements that you look at for security rule violations. So you want to make sure that you are regularly conducting that risk analysis and updating it as appropriate to the particular circumstances. To help you do that, the government has published a security risk assessment tool that you can go in there and use this tool that kind of walks you through the analysis for your systems as well as the regulatory requirements for that. It's free. You can access it here on this government's website. You're not required to do this, but especially if you're a smaller provider, you may want to use this as an alternative to hiring a relatively expensive overall security audit. The key here, though, is to make sure that you're not just jumping through the hoops, that you are conducting an effective risk analysis that will allow you to put in place the safeguards you need to protect your data, not only to protect it under the regulatory standards, but to make sure as a practical matter that you're protected from cybersecurity as well as just, accidental loss or damage to your data. Once you've done that security analysis, you need to implement the appropriate safeguards. As I mentioned, the privacy rule or the security rule has specific safeguards. They're broken out into buckets. You have certain administrative safeguards, physical safeguards, and technical safeguards. Now, these safeguards are not technologically specific. They don't tell you that you must have this particular software or that particular hardware. What they do is set standards that you need to make sure that whatever system you are using is compliant. Your implementation is designed to be scalable, depending upon the size and complexity and capabilities of the entity, the costs, and the probability and criticality of the risk to the EPHI. Now, some of those standards are required, meaning obviously that you must satisfy those standards. Certain other standards, at least under the current rules, are addressable, which means that if for an addressable standard, you're not necessarily required to implement that standard. Instead, you're supposed to assess the reasonableness of the specification. If it's reasonable, you're expected to implement it. If it's not reasonable, it doesn't mean you can't ignore it. It means you've got to document why it's not reasonable and implement alternatives that are at least as effective if those are reasonable. And then you must review and modify as needed. Now, importantly, under the proposed rule, all the standards are going to be required. They're not going to be having the addressable standards under the rule. All right, with that general overview of the standards, briefly, with the administrative safeguards, it requires you to put in place a security management process. That involves having your risk analysis, and you've got to sanction your workforce members for violations. You've got to regularly review your system activities through things like audit logs, access reports, security and incident tracking reports, or so forth. In addition, you've got to assign security responsibilities to an appropriate person, your security officer, who, by the way, has to be designated in writing. You've got to implement certain standards regarding workforce security, including authorizing and supervising workforce members who work with your EPHI. You have to have a process to determine if the workforce access is appropriate for that particular person. You need to have a process to terminate that access when it is no longer required for that person's job duties or for the functions that you perform. You've got to have access management processes, a process to grant access to EPHI through example, workstation protocols or safeguards, transactions, programs, etc. You've got to establish, document, and review those processes as appropriate and modify the access as needed. You need to have a process for security awareness and training, including periodic security reminders and updates for your workforce. Processes regarding against detecting and reporting malicious software, monitoring login attempts and reporting discrepancies, creating and changing and safeguarding your passwords. You've got to have administrative processes for security incident procedures, how to identify, respond to, and mitigate suspected or known security incidents, and document the appropriate responses. And you've got to have an appropriate contingency plan to take place if, for example, there's a fire or vandalism or system failure or hacking or ransomware or a natural disaster. How can you got to have a way so that you're backing up your data and have a data backup plan, disaster recovery plan, emergency mode operation plan, testing and revision of contingency plan, applications and data criticality analysis, and a periodic evaluation of the security rule compliance. Those are the administrative standards. You've also got to put in place your physical safeguards to protect your data in your facility. That includes facility access controls, contingency operations that allow access to EPHI under disaster recovery and emergency mode operations, safeguards against unauthorized access, tampering, or theft at your facilities or to the EPHI, control and validate the person's access based on their role or function, including visitors, document repairs and modifications to your physical structures, such as hardware, walls, doors, locks, etc., workstation security, including safeguarding access and restricting access to authorized users. You got to have device and media controls, including processes concerning the receipt, removal, and movement of hardware and electronic media, both within and outside your organization. Your processes have to have a process for the final disposition of EPHI or hardware on which it's stored, and a process for removing your EPHI from the media prior to any reuse. You have got to document the movement of your hardware and electronic media and persons responsible for the same, and create retrievable exact copy of your EPHI before the movement of that equipment. Those are the physical standards. The technical safeguards, you've got to have, again, technical access controls. Among other things, you've got to assign a unique name or number for identifying and tracking users. You've got to have emergency access procedures, automatic log off after a predetermined time of inactivity, encrypt and decrypt your EPHI. I'll talk about that more in a minute. You got to have audit controls that record and examine activity in your information systems, data integrity processes to protect against improper alteration or destruction of ePHI, electronic mechanisms to corroborate that the ePHI has not been altered or destroyed in an unauthorized manner. You've got to have user authentication to verify that a person seeking the access to the ePHI is the person that's actually authorized to do that. You've got to have transmission security protections to guard against the unauthorized access to ePHI that is transmitted over an electronic communications network, including unsecured networks like the internet or text messaging, things like that. You've got to have integrity controls to ensure transmitted ePHI is not improperly modified without detection, and encrypt ePHI whenever it's deemed appropriate. All right. A word about encryption. Note I've mentioned encryption a couple of times. Encryption is an addressable standard, for both data at rest as well as data transmission. That means presumptively all of your data, your electronic data, is supposed to be encrypted no matter wherever it's located. Now that's addressable. It doesn't mean that you have to do that, but if you're not going to do it, you've got to establish that it's not reasonable to do it and that you come up with reasonable alternatives for doing it. It's kind of hard to come up with a reasonable alternative to encryption. Encryption is kind of like the standard out there that they expect you to be complying with. Encryption is important also from the breach rule because ePHI that is properly encrypted is secured, because the breach reporting rule only applies to the breach of unsecured protected health information. If your data has been properly encrypted, then it's deemed to be secured, and therefore you don't have to report the breach. So there is an incentive for you to make sure that your data is properly encrypted. On the other hand, if you happen to lose an unencrypted laptop or USB, a mobile device that contains electronic protected health information, the OCR takes the position that that is presumptively a breach unless you can somehow convince them that it's not a breach. So you want to make sure that you secure that information so that if it is lost or stolen or whatever, that no breach has occurred. The government's concerned about mobile devices. They have a website dedicated specifically to what you can and should do in order to minimize your risks concerning mobile devices, including storing protected health information on your phone. When it comes to communicating by email or text, remember that the standard is you shouldn't be communicating protected health information unless it's encrypted. Texting using a regular text system, a platform over the internet probably isn't going to be encrypted. Text over the phone line or texting, most texting services are not encrypted. That means the rule generally says you can't use email or texting unless you've got a secure platform for that. Now, there is a caveat to that because, as we talked about a couple of weeks ago, under the privacy rule, patients have a right to request communications by alternative means or at alternative locations. That means if they want to, they can request and have you send their information to them in an unencrypted manner, either through unencrypted email or unencrypted text. And as long as you've notified the patient of those risks and they agree to accept those risks and agree that they want to have that information via unsecure email or text, then you can go ahead and send it that way. Otherwise, you shouldn't be communicating with your patients via unsecured email or text if you're sending any kind of ePHI, which of course the patient's name and their ISP is PHI. Now, that loophole or that out for communicating with patients does not apply to others. Communicating with your workforce members and the like, there is no exception that allows you to use unsecured texting. So if you're communicating communicating ePHI via unsecured texting or unsecured email, then you're violating the HIPAA, presumptively violating the HIPAA security rules. So be careful about communicating via email or text. All right, let's talk about business associates. Under the privacy and security rule, you may disclose protected health information to business associates, but only if you have a valid business associate agreement with that business associate. So covered entities, you've got an obligation to have a business associate or BAA with your business associate. Business associates, if you're using subcontractors to complete those obligations for the covered entity, you've got to have a BAA with your subcontractor. The failure to execute a BAA, that would be a HIPAA violation, and it may subject you to HIPAA fines, either because of your direct violation under the HIPAA penalties. But also in some of the OCR settlements, they basically say that, look, if you didn't have a BA in place and your business associate violates it, then we're going to hold you vicariously liable, essentially, for what that business associate did. I think that's the wrong legal analysis, but that appears to be what they're saying. So you want to make sure that you've got appropriate BAAs in place with business associates or subcontractor business associates. The key here is understanding who is and is not your business associate. A business associate is an entity that you want to have your protected health information. They're an entity that you're contracting with to perform some service on your behalf involving your PHI. It would be like your IT vendor, your billing company, independent contractors who have access or need that information, your attorney, your accountant, any of those people, a cloud storage vendor that's maintaining that. If they're receiving, creating, maintaining, or transmitting PHI, then you generally need to have a business associate agreement with them. It could also include other covered entities, but only when they're acting as business associates for you on your behalf. So, example, if you're paying a physician not to provide medical services, but to provide, administrative services like a medical director, or you're paying consultants or peer reviewers or things like that, then they could be business associates. Subcontractors of business associates who are providing services relating to those protected health information are also business associates and would need a business associate agreement. But it's the obligation of the business associate to get the business associate agreement in place with that subcontractor. Well, who are not business associates? Well, it would be those persons who you do not want to have your information, right? It also includes members of the covered entity's own workforce. You don't need to have a business associate agreement with your own workforce members. You should have a confidentiality agreement, but you're not required to have a BAA with them. It does not include entities do not handle PHI as part of their job duties. So, for example, you may have an independent contractor or janitor who comes in at night. Are they going to have potentially access to protected health information? Yeah, but you don't want them to do anything with it. It's not like you're saying, come in there and, mop the floors and check out our PHI while you're in there. That's not part of their job duties, and therefore they would not be a business associate. Again, good idea to have a confidentiality agreement, but not a BAA. Entities that receive PHI to perform functions on their own behalf, like banks, other insurance companies, when you're engaging in those transactions with them, they're not performing services for you, they're performing services on their own behalf, and therefore they're not a business associate. Other healthcare providers who are simply providing treatment, they are not your business associates, they're just other healthcare providers. So you can share information with them for treatment, payment, and certain healthcare operations, but without getting a business associate agreement in place for them. Data transmission companies that do not routinely access protected health information, they're not your business associates because they aren't and should not be accessing that information. They are essentially just a conduit, the pipeline for transferring that information. On the other hand, if they are storing or accessing that information as part of their job duties, then at that point, then they may become business associates. Members of an organized healthcare arrangement are not business associates. That's basically entities who come together to provide care coordination, things like that. They're not business associates. If you want to know who your business associates are or help identify those, I've published a helpful decision tree that you can go in there and use that. You can access it along with an article that I've done on those issues. All right, a word on cloud computing, because now that we're all doing cloud computing, right? Sometimes you get situations where the cloud vendor is claiming that they are not a business associate. And in that situation, you may have to go back to them and either stop working with them or make sure that they complete a business associate agreement. The OCR has issued guidance on that, and they specifically said that when a covered entity or business associate engages the services of a cloud service provider to create, receive, maintain, or transmit ePHI, including just maintaining it out there on the web, such as to the process and or storing the ePHI on its behalf, the CSP, the cloud service provider, is a business associate under HIPAA. They are maintaining or that data. This is true even if the CSP processes or stores only encrypted ePHI and lacks an encryption key for the data. I used to tell clients prior to this guidance that should not be considered a business associate because it's encrypted. They shouldn't have access and shouldn't be using it. But the government came out with this guidance and says, no, they're maintaining it, so they still should be a business associate. And as a result, the covered entity or business associate and the CSP must enter into a HIPAA compliant business associate agreement. And the CSP is both contractually liable for meeting the terms of the BAA and directly liable for compliance with the applicable requirements of the HIPAA rules. The bottom line is, if you're using a CSP to store or transmit your protected health information, then you need a business associate agreement with them. If they're going to refuse to sign that, then you're using them at your risk and you're in violation of HIPAA for doing that. I should point out that if you are a business associate, you're a business associate and subject to HIPAA whether or not you have a business associate agreement in place. So those cloud service providers and the others who are functioning as business associates, they're going to be covered by HIPAA and subject to those responsibilities, even if they don't have a business associate agreement in place. But you'll want to make sure that you get that in place, both so that you are protected under HIPAA and also that you have contractual rights against that cloud service provider should they violate HIPAA. Those business associate agreements must contain certain required terms. If you are a business associate who is executing arrangements with subcontractors, you need to make sure that those business associate terms in your agreement with your covered entity are passed through to your subcontractor. And remember, a business associate is still a business associate and subject to HIPAA, even if there is no business associate agreement. I'm not going to go through the required terms, but periodically you may want to call up and check your business associate agreements to make sure that they are in compliance with the requirements under HIPAA that are found at 45 CFR 164.314, as opposed to the security rule requirements and 164.502 and 504 for the privacy rule requirements. Especially beware of situations if the business associate wants to use the protected health information for its own purposes that are not permitted by HIPAA, including its own product development, data aggregation, data mining, or tracking. All of those things, when that business associate agrees to receive that or you're contracting with them to perform those services, they can only use that data to perform those services on your behalf. They can't then use that data for their own purposes, with very, very limited exceptions for basically their own business administrative purposes, but not general business purposes, anything they want to do. So you need to make sure that both your business associate agreement does not allow them to do that, and if you become aware that they are doing that, then you need to take affirmative obligations to stop them from doing that. The OCR has published sample business associate agreement provisions. My advice, though, is don't use their sample provisions. They are not that good, and sometimes they impose greater liabilities or are not as helpful to you as you might need. On my website, we've got a HIPAA checklist and some guidance concerning what you may want to consider in making sure that your business associate contracts have in place. Again, you want to make sure that you have appropriate business associate agreements to protect yourself both under HIPAA and for liability for what that business associate does. Because if you know that a business associate is screwing up with your information and you don't fail to take action, then that can be a violation under the HIPAA rules. You are liable for a HIPAA violation. That is a separate HIPAA violation. In addition, you need to be careful because if that business associate is acting as your agent, then you can be vicariously liable to them under the HIPAA rules. If under the federal common law of agency, they are determined to be your agent. That generally means that you're exercising sufficient control over them, that you can control what they are doing, and therefore you are responsible for what they're doing. To minimize your liability for your business associate's misconduct, there's some things that you can do. Obviously, you need to have your business associate agreement in place and make sure that it contains certain terms. Among others, you're going to want to confirm that they're an independent contractor, that they are not your workforce member or your agent, so that you're not vicariously liable for what they do. You want to make sure that they are going to cooperate with you in responding to any breach. Hopefully, you can get them to pay for or include provisions that require them to pay for the cost of any mitigation, defend and indemnify you for any breach that's caused by the business associate or perhaps their subcontractors, and perhaps require that they maintain appropriate cyber liability insurance so that if there is a breach, that it can protect you. You're going to want to also, as a practical matter, don't exercise too much control over the business associate, because remember, if they become your agent, if you exercise such control that they become your agent, then you're going to be vicariously liable for what they do. So be careful about getting too involved such that they become your agent and you're vicariously liable for what they do. If you do learn that they're messing up with your information, you need to take appropriate steps to respond immediately, and if necessary, terminate the business associate agreement and your services agreement so that you're not vicariously liable for what they do. All right, final aspect of the security rule, you've got to maintain and implement written policies and procedures to ensure that you have complied with or implemented all of those standards and specifications. You've got to maintain that documentation in written or electronic form. That documentation has to be maintained for 6 years. There's sometimes some misunderstanding. Some people think that HIPAA requires you to maintain the electronic protected health information for 6 years. That's not the case. It just requires you to maintain the documents that are required by HIPAA, like your notice of privacy practices, your written policies and procedures, your designation of your security officer, that type of stuff. That has to be maintained for 6 years. You've got to maintain those documents, make those documents available to persons responsible for implementing those procedures, and you've got to review and update your documentation periodically in response to environmental or operational changes affecting the security of your EPHI. Under the proposed rules, they will have timelines for doing that. Now, for all of those rules that we just talked about, if you want a quick checklist, there's a checklist of those requirements along with the regulatory citations that you can access as an appendix to the regulations. You can access them at the website, or we've got a kind of a checklist for you that you can access on our firm's website if you wanted to go through and make sure that you have all of the required safeguards in place. The government has, because security is so important, the government has got a lot of helpful resources for helping you comply with the security rule. The OCR has a kind of a website that has a bunch of links to different things, including the Security 101 series, risk analysis resources. They've got the OCR cyber awareness newsletters and so forth. You can access it through that portal. I think that the HIPAA 101 security educational series it's pretty basic, but for you, those of you who may be like me and are not necessarily technology gurus, it kind of reduces a lot of these rules down to common sense or common understanding of what you need to do. The Health IT also has a lot of additional resources. The healthit.gov website, including tools and templates for security rule compliance. They've also got a bunch of education and training resources. If you haven't looked at that recently, you may want to do that. Make sure that your IT people are aware of those resources. All right, that is a quick overview of the current security rule. Let's talk just briefly about the proposed rule. On January 6, 2025, the former administration published the proposed security rule because of all of the major concerns about cybersecurity and the like. If and when it's adopted, and if it's not changed, those changes would generally take effect 180 days after that final rule is published. So you'll have about 6 months in order to implement these new rules. As I mentioned, under those proposed security rules, it now lists a bunch of required standards. It eliminates all the addressable standards. All of those standards are going to now be required. In addition, unlike the current rule, it puts in place timelines for when you must do stuff. Specifically, at least once every 12 months, each covered entity or business associate are going to have to review and update their written inventory of their devices containing EPHI and the network map concerning the flow of EPHI. You've got to review and update the written risk analysis to addressing the elements specified in the rule. You've got to review and or update the written risk management plan, review and test policies and procedures concerning those required standards, review and update your workforce sanctions policies, review and test written policies concerning system activity reports, and review and update your workforce security policies. So this is going to be a major sea change from what a lot of you have been doing. It's going to put these timelines where it's going to be an ongoing obligation to do this at least on an annual basis. The new rule also puts in place additional, very specific administrative, technical, and physical safeguards that build on what was in place before. I'm not going to take the time to go through those just because we haven't got the final rule yet, and I don't get overly excited about the proposed rule until it actually takes final place. And despite my best efforts, I have not heard from the new administration exactly where this is going. But generally, as I mentioned, for all of these new safeguards, you're going to have to review, update, and test those policies on an annual basis. There's also new standards for proposed physical safeguards and new standards for technical safeguards that you're going to have to put in place. There's also standards for business associate agreements. They haven't changed a whole lot other than you're going to have to require, as a covered entity, you're going to have to require your business associates to report the activation, report any kind of activation, of its contingency plan. So if they have a security incident or need to implement its contingency plan, then they have to notify the covered entity. They probably have to do that already as an incident report, but be that as it may. If you want more information about the proposed rule, there's a lot of stuff out online about it, but you can also go to the OCR's website where they have a fact sheet. Now, this is somewhat significant because for those of you who follow the OCR's website, who are kind of nerds like I do, you will note that the new Trump administration had taken down some of the different guidance that had been issued by the Biden administration, including things like the 1557 standards and things like that. But when it comes to OCR privacy or the security rule stuff, it's still there. I think that that means that the Trump administration, just like Congress as a whole, realizes how important this is, and therefore we are going to get some kind of final security rule coming down the pipe. I'm not sure exactly if it will be in the form that was proposed, because the proposed form is pretty draconian, but given the risks and the consequences and the stakes that are involved in cybersecurity threats against healthcare security, I think that we will see a pretty robust security rule coming down the pipe. As further evidence of that, in April, we've gotten several settlements out of the OCR, the new OCR under the new administration, that reemphasizes their commitment to security rule compliance. For example, in the April 17th report that they did on a data security, which, by the way, this language I just checked, and this language is copied for the one that just came out yesterday. In both of those situations, the OCR went out of its way to state that the OCR recommends that healthcare providers, health plans, and business associates that are covered by HIPAA take the following steps to mitigate or prevent cyber threats. Identify where EPHI is located in the organization, including how EPHI enters, flows through, and leaves the organization's information system. I mean, that's talking about the data analysis and the network flow agreement or flow process in the proposed rules, it appears. You've got to integrate that risk analysis and risk management into the organization's business processes. Ensure that audit controls are in place to record and examine information system activity. Implement regular reviews of information system activity. Note that it says implement regular reviews. That may be even better than or more regular than periodic, right? So it seems to be an ongoing obligation. You've got to utilize mechanisms to authenticate information to ensure only authorized users are accessing EPHI. Encrypt EPHI in transit and at rest to guard against unauthorized access to EPHI when appropriate. Incorporate lessons learned from incidents into the organization's overall security management process, and provide workforce members with regular HIPAA training that is specific to the organization and the workforce members' respective job duties. The bottom line there is that sounds somewhat similar to what was in the proposed rule. So I would not be surprised to see the proposed rule come out with, again, pretty robust requirements. They may not track exactly what was in the proposed rule, but they may be relatively close. All right, that is the proposed rule. Just in the last few minutes, I want to talk about some of the other highlights of things that have been going on with the security rule. One of those is the guidance that came out last year from the OCR concerning HIPAA and online tracking technologies. All right. Looks like the slides. There we go. Um, there were some cases and some articles that had come out over the last few years that were very critical of hospitals that were using online data tracking in order to, um, excuse me, online tracking tools. Okay, there we are. Sorry about that. Using online tracking technologies through website apps and things like that, like cookies, web beacons, tracking pixels, session replays, all sorts of things like that, that these either the hospitals were using them themselves or their website vendors or other people were using these tracking technologies that were embedded in the websites and other data security measures. They were using that for purposes that weren't necessarily permitted by HIPAA. They didn't think that, they may not have thought that that was covered by HIPAA, but remember that ISP addresses, names, any of that stuff is protected health information. It's individually identifiable information. So if you've got that ISP address and it's linked to particular individuals and is somehow tied to their healthcare, then it becomes PHI and covered by HIPAA. Then that means that you can only use that information for certain purposes that are permitted by HIPAA, including treatment payment or certain healthcare or certain healthcare operations. But healthcare operations is not anything that you want to use it for. It's only very limited types of uses. And just simply using this data tracking stuff for data mining, for marketing, for all of those types of things does not fit within necessarily a permitted HIPAA exception. And therefore, OCR came out with this guidance and said, hey, if you're using these tracking technologies, you may be violating HIPAA, and so you need to be very careful. And the guidance was very broad. It applied to it would apply if somebody just went to your website and you were tracking it. Of course, a lot of people were upset with that and said, well, wait a minute, just because I access a provider's website, but I don't otherwise have a patient relationship with them, I mean, how does that implicate HIPAA? And lawsuits were filed. The bottom line is in June 2024, a district court issued an order declaring unlawful and vacating that guidance, but only to the extent it provides that HIPAA obligations are triggered in circumstances where an online technology connects to an individual's IP address with a visit to an unauthentic public web page addressing specific healthcare conditions. So simply by going to a web page, if you're just tracking that information, probably not protected. But on the other hand, if it's tracking users behind an authenticated web page where you had to go in and input the patient's data or the patient inputted their data, then in that situation, it may actually violate HIPAA if you're tracking that information for a purpose that's not permitted by HIPAA. The bottom line is be really careful about these data tracking technologies. Make sure that your vendors are complying with your HIPAA obligations. As part of that guidance, the government emphasized, the OCR emphasized that how important it is to comply with the security rule, that the OCR's prioritizing compliance with the HIPAA security rule and investigations into the use of online tracking technologies. They state that you should include that tracking technology in your risk assessment and include required administrative, technical, and physical safeguards when it comes to using that tracking technologies. So beware of what may be going on out there that you as compliance professionals may not be aware of. There's been kind of a cottage industry that's sprung up among some plaintiffs' law firms where they're going after hospitals that are using these tracking technologies, using HIPAA kind of as a baseline or state privacy laws in order to bring class actions against entities, hospitals, and others for using these online tracking technologies. All right, just real quickly, a word about the breach notification rule. I talked more about it a couple of weeks ago. But remember, if there is a breach of unsecured protected health information, the breach notification rule requires the covered entity to notify individuals whose unsecured protected health information has been or is reasonably believed to have been accessed, acquired, used, or disclosed. In addition, you've got to notify HHS. The only difference is the timing, depending on the number of persons who are affected. If the breach involves more than 500 persons, you've got to notify local media. If you're a business associate, you have to notify, and you become aware of a breach, you have to notify the covered entity so that they can report that breach. Note that a breach that triggers the breach notification rule applies to the acquisition, access, use, or disclosure of PHI in violation of the privacy rule. A security rule violation itself is not reportable. It has to be there has to be a breach of PHI that violates the privacy rule. But of course, if somebody has improperly accessed or used that data, even if it's an electronic protected health information, then it is a violation of the privacy rule, and you would have to report it unless you can determine that there's a low probability that the data has been compromised based on an analysis of those 4 risk factors. Now, importantly, as I mentioned earlier, the loss of secured data is not a breach. The breach is only a breach of unsecured protected health information. If that data has been secured, i.e., under the OCR's guidance, if the data has been secured through proper encryption, then there has not been a breach, and therefore you would not have to do the breach report. Now, when it comes to ransomware, the government has taken the position if you get hit by ransomware that effectively comes in there and encrypts all of your data, even though there's no indication that the bad guy has actually accessed or exfiltrated that data. I used to take the position that, well, if there's no evidence that it had been exfiltrated, just simply the encryption of it was not a breach. The OCR takes a different view of that. In the guidance that they came out, they said that when ePHI is encrypted as a result of a ransomware attack, a breach has occurred because the ePHI encrypted by the ransomware was acquired, i.e., the unauthorized individuals have taken possession or control of the information, and thus a disclosure not permitted under the HIPAA privacy rule. So there is a violation. So it's going to be reportable unless the covered entity or business associate can demonstrate that there has been a low probability that the data has been compromised based on the factors set forth in the breach notification rule. So the bottom line is, if you get hit with a ransomware attack, that is presumptively a breach that you're going to have to report to the government and everybody, all of those individuals whose data was impacted by that ransomware attack. That's the presumption, unless somehow working with your team, you can do this risk analysis and conclude that there's a low probability that that data really was compromised, which may be difficult to do. That ups the stakes in ransomware attacks. You may want to go, if you haven't already, go in there and look at this guidance on the ransomware and HIPAA. Among other things, it gives a lot of helpful guidance for healthcare providers concerning preventing ransomware, how to detect ransomware, how to respond to ransomware attacks, and evaluating if there is a breach, including the application of the risk factors when it comes to a ransomware attack. Just a word about the Change cybersecurity breach. I'm sure all of you have been impacted by that. I mean, it's the poster child, right, for the far-reaching impacts of a cyber attack. Not only that, but remember that the Change cybersecurity issue is still going on. The government has posted FAQs about that because it affected millions and millions of healthcare providers. The government periodically updates that guidance. The thing I wanted to alert you to is even though that breach occurred by Change, which is your business associate, U.S. covered entities are still required or responsible for making the breach report to the affected individuals, unless you've worked out with Change that they're responsible for making those notifications. So just be aware of that. All right, in the final 5 minutes, I just wanted to talk briefly about some general cybersecurity issues. Cybersecurity, huge issue at HHS. In 2023, HHS published its strategy for addressing healthcare cybersecurity. Among other things, they wanted to implement greater enforcement. That's why we've got the new cybersecurity rules. Look for new enforcement, including potentially increased civil penalties for security rule violations. The government has posted a bunch of helpful resources on cybersecurity for healthcare providers and other entities in the healthcare space. They've come up with a cybersecurity gateway, so you can go to this gateway and it will lead you to a whole bunch of other guidance, including certain goals that HHS has published. These are not mandatory, but they are recommended goals that healthcare entities ought to look at. It gives you links to the NIST guidance on different cybersecurity standards. It will also take you to cybersecurity guidance that's issued by HHS through OCR. Among other things, it's got a whole bunch of cybersecurity updates, newsletters that can help you with your cybersecurity awareness and responding. I think that the October 2024 version of the cybersecurity newsletter is especially helpful for any of you who want to provide training to your staff concerning things like social engineering, like phishing, smishing, and the like. It explains what it is and what you need to do in order to protect your organization, since that's a common vector for ransomware attacks. In fact, it was a phishing attack that resulted in the settlement, the $600,000 settlement that the OCR put in place yesterday. In addition to the cybersecurity or the HIPAA security rule, Congress is considering additional legislation implementing cybersecurity guidance. Last year, legislation was proposed, the Health Infrastructure Security and Accountability Act, which was kind of the cybersecurity rule on steroids. It looks like that now has died. It's probably not going to go forward, but I think that there are efforts to come up with alternatives. So watch for federal legislation, because it's probably going to be coming down the pipe. A word about FTC. The FTC is also getting involved. You not only have to worry about the OCR, but also FTC under the the FTC Act, where the government is taking the position, or the FTC is taking the position that, we're here to protect against unfair trade practices. If you are out there representing that you are keeping the data secure and you're not, then we can come after you for penalties under the FTCA. In addition, if you're just simply not taking appropriate steps to keep data, client data or customer data confidential, then we can come after you for that. So it's not limited to just healthcare entities. It's an alternative to the government coming after you in addition to HIPAA. And there have been a whole spate of cases that have come down concerning FTC enforcement actions. A word about FTC actions and also your general privacy practices or notices. As covered entities and business, or as covered entities anyway, you have to have your notice of privacy practices. But if you maintain a website, you probably also have other privacy terms and conditions related to your website. Sometimes the two organizations or two departments within your organization have not collaborated on those. And it may be that your website privacy terms do not track what your notice of privacy practices are. You may go into your website privacy terms that say something like, we can use your information for these purposes or for data tracking purposes and these types of things that are not permissible under your notice of privacy practices. So you may want to compare the two and make sure that they coordinate so that your website privacy terms are not violating or in conflict with your notice of privacy practices. Finally, make sure that you're aware of data privacy laws that are in states. More and more states are passing some form of data privacy law. I think all states have some kind of breach reporting requirement already, but more and more states are enacting various forms of data privacy laws that may impact just healthcare providers or may impact other types of industries. So make sure that you're aware of that in your particular state. Remember that under HIPAA, if a state law is more restrictive than HIPAA, then you've got to comply with that more restrictive law in addition to HIPAA. All right, that is a quick overview of HIPAA security rules. If you want more information, the OCR has lots of information about HIPAA for professionals. They've taken down a bunch of the HIPAA stuff that they had out there, but this website for HIPAA for professionals is still up, so you can access it. If you're kind of a novice in this and you want a beginner's look at what this is, the Office of the National Coordinator for Health Information Technology has published a guide to privacy and security that I think is quite helpful. That could be a good resource for you. We also have a bunch of free resources on our website, including templates, checklists, things like that for all sorts of HIPAA compliance. You can access that for free on our website. Other than that, if you have questions, we did not take questions during this program. It is recorded if you want to listen to it again or send it off to whoever. In addition, if you have questions about anything that I've said, you can go ahead and use those, submit those using the chat feature on the web page, or you can go ahead and just email me, and I will try to respond to those offline. Thank you very much. Appreciate your participation in today's program.